member should speak for at least 20 minutes. Extension of timing shall be at the discretion of the judge. However, the judge may grant an extension not more than 5 minutes per team. All the speakers in the session must change their view to the gallery view. In no case, researcher would be allowed to plead. However, he or she is allowed to pass text in the chat box to the orator. Case compendium, or any other relevant material to be submitted to the judges should have been done in advance. No team shall indulge themselves in any act or misconduct in or out of the courtroom, undermining the credibility of judges, which may lead to immediate disqualification. The teams should leave the courtroom immediately after the session. No feedback will be given to the participants by the judges or the courtroom volunteers. Teams are expected to wear formals for the rounds. All members of the team are expected to turn on notifications before entering the meeting for receiving the time intimations during the rounds. The time will be communicated through the chat box periodically. Teams are to keep a check of the chat box for the same. The timekeeper will hold a placard when the time is up. All teams are to keep themselves on mute and switch on their audio only while presenting. The participants shall keep their videos on at all times.
A very warm and pleasant greetings, respected judges. The council seeks permission to collectively refer the bench as your lordship.
Yes, please.
Much obliged, your lordship. Your lordship, the council represents the matter of the petitioner in the matter of BOI versus Union of India and others. The council shall be dealing with the first and second issue pertaining to the validity and reasonableness of the notification, followed by sharing of personal data sets with the government and free public. Your Excellencies, should there be no preliminary concern, the council seeks permission to present the facts of the case.
With the permission of the other brother judges, if we can skip this part, it will be better, I guess.
I think we are quite familiar with the facts.
Most certainly, your lordship. Your lordship, the council seeks permission to move to issue number 1.
Yes, please.
Much obliged, your lordship. Your lordship, the council shall be dealing with the first issue in a threefold manner. It will attempt to establish that firstly, the notification lacks the force of law. Secondly, that the said notification is unfair and unreasonable in nature. And thirdly, that it fails to satisfy the test for imposing a valid restriction on the fundamental right to privacy. Your Honours, the council humbly contends that the notification issued by the Ministry of Home Affairs on 30th March 2020 did not possess a legitimate force of law owing to its enactment under Section 35 of the Data Protection Act. Your Lordship, shall the bench refer to Section 35 of the Act, it may see that the Act does not provide for any exemption for the government to process the data sets, but it provides an exemption for the government agency, your Lordships. Therefore, your Lordship, the council, the council contends that the government could not have sought to the processing the data as it may have deemed fit as claimed under the notification. Furthermore, your Lordships, Section 3, subsection 13 of the Data Protection Act distinctly marks a dichotomy between the term person, state, and company whilst defining data fiduciary. Herein, your Lordships, the very base of the notification under the blanket of Section 35 of the DPA is not admissible, as Cobalt, which is a company, did not fall under the purview of a government's agency, nullifying the asserted legislative backing. Your Excellencies, should you refer to paragraph 4 of the moot proposition, it specifically talks about the term saying the government having tie-up with a foreign medicine company, Cobalt. Your Lordships, by the word tie-up, it does not justify that there is a contract between them. And your Lordship, no pre-assumption can be derived. Your Lordship, the government ordered Cobalt under an executive notification, and therefore, your Lordship, and the facts of the case, your Lordships are silent on the fact whether there is a contract. Therefore, your Lordship, it cannot be certainly said that it is an agency. And therefore, your Lordship, such an exemption cannot be provided under Section 35 of the Data Protection Act, which talks about an exemption to process under the government's agency. Further on, your Lordships, Section 36 of the Data Protection Act lays out the exemptions of certain provisions without specifying any distinction between a person, state, or a company Instead of resorting to a relevant statute, your lordships, the immunity was sought under Section 35, which isn't applicable in the present case. Furthermore, your lordships, this honorable court in the case of Commissioner of Customs, Mumbai versus Dilip Kumar and company and others, held that the exemption notification should be interpreted strictly, and the burden of proving of the applicability should be on the respondent. And should there be any ambiguity or excellencies, the benefit cannot be availed by the respondents. Furthermore, your lordship, the government or cobalt does not fall under the ambit of Section 35 of the Act, your lordship. Owing to this, the notification lacks the force of law. Your
Counsel, sorry, though we thought that we'll not interject, but I think this cardinal point that you've raised, that Section 35 does not apply to the government but to government agencies. Do
Yes,
you
yes.
have any judicial precedent to substantiate where this specific point, and again, I'm being very, very specific, government versus government agency, this distinction has been brought about?
Most certainly, your lordship. Your lordship, here in the council is strictly relying to the facts of the case, your lordship, because the facts of the case are not really backing up, and the facts of the case are silent on this note, your lordship, and reliant on the precedents, your lordship, it is actually a bill, your lordship, and not an act. So the council will not be able to present a asserted.
Also, my second question to you here is, you have conveniently said a tie-up does not mean a contract. We really do not think so, because I think if you take it in the normal commercial parlance, a tie-up would have a contractual arrangement. Anything to say on that, and then you can
Most
proceed.
certainly, your lordship. Most certainly, your lordship. If we refer to Section 182 of the Indian Contract Act, from 182 to 189 of the Indian Contract Act, your lordship, there is a principle that is established that there is a degree of control of the principal over the agent, your lordship. So, your lordship, the council is contending that the facts, nowhere in the fact that it is asserted, your lordship, that the government is exercising some kind of a control. And your lordship, the only control that is displayed in the facts is the notification, your lordship, and it is an executive notification. Nowhere has it been explicitly mentioned about the contractual obligations, your lordship. And
Please
your lordship,
proceed. You can proceed. Thank you.
much obliged, your lordship. Your lordship, in the Supreme Court of Menaka Gandhi versus Union of India, it had clearly been established that the procedure prescribed by law has to be fair, just, and reasonable, and not oppressive and arbitrary in nature. Your lordship, there should also be the existence of a law, which is the first requirement. The second requirement is that of a legitimate state aim. And your lordship, the nature and content of the law which imposes the restriction within the zone of reasonableness, your lordship, which falls under Article 14, which is a provision against arbitrary state actions. Your lordship, in the instant case, during the times of uncertainty and distress, the state had no qualm of the violated measure that sought to fighting the COVID-19 situation. It went on to levy this notification, your lordship, and the council courts. The government may process the personal data collected by Cobalt in any manner it may deem fit. Your lordships, it may deem fit is highly open-ended, which is gravely unreasonable and disobliging. Your lordship, the action that invades the rights of the citizens in an unjustified manner cannot be regarded as reasonable. To establish the reasonability of any restriction, it should be viewed from the view of a general public, your lordship. Your lordship, in the case of Narendra Kumar and others versus Union of India, this apex court had established that the courts ought to apply the test of reasonableness and consider the facts and circumstances under which the order was made, taking into account the harm caused to the individual citizens by proposed remedy and whether the restraint, your lordship, by the law is more necessary in the terms of general public. Furthermore, your excellencies, right to privacy under Article 12 of the Universal Declaration of Human Rights and Article 17 of the International Covenant of Civil and Political Rights are defined as, and the council quotes, no one shall be subjected to arbitrary interference with his privacy, family, home, and correspondence, nor to attack upon his honor, reputation. Everyone has the right to the protection of law against such interference or attacks, your lordship. Your lordship, in the instant case, there is no nexus of the notification with the objective with which the government seeks to achieve. Also, in addition to this, the government resorts to taking immunity via the notification after violating the fundamental rights of the citizens without any answerability, which makes it gravely unfair and unreasonable. Furthermore, Your Lordship, the Supreme Court laid down the test of proportionality in the case of K.S. Puttaswamy versus Union of India. The four basic quintessentials for restriction to be deemed reasonable is that firstly, it should be for a designated purpose, Your Lordships. Secondly, that the measure undertaken are rationally connected to the achievement of such goal. Thirdly, that the measures undertaken are necessary and there is no other alternative to achieve such goal with lesser degree of restriction. Lastly, Your Lordship, there should be proportionality stricto sensu. Your Excellencies, whilst the Council deeply respects the government's claim of the purpose of restriction being national security and integrity. However, Your Lordships, breaching the sensitive personal data of its citizens on a news channel where there is threat from terrorist organization is an absolute contrast to what the government is claiming. The question, Your Honor, lies that what if the terrorist organization access the data? Is there no threat to national security then, Your Lordships? Your Lordship, the purpose and the ground reality are not commensurate to what the government is claiming. Furthermore, Your Excellency, Section 35 provides extensive grounds for exemption, but does not provide a procedure to be followed while processing personal data under this provision. Your Lordship, in the instant case, though the notification was issued for safeguarding the integrity and security of the country, it does not take into account its ambit, the relevant repercussions of it on the fundamental rights of the citizen without any accountability. Therefore, in addition to being unreasonable, Your Lordships, it failed to also meet the test on imposing the fundamental right to privacy. Your Lordships, should there be no preliminary concern, the Council would request the court so that the Council moves to issue number 2.
Well, I have one question again. So you were relying on Section 35 of the DP Act. What about Section 35 of the DM Act?
Your Lordship, could you enlighten the Council as to Section 35 of which Act?
The Disaster Management Act, DM Act.
Most certainly, Your Lordship. Your Lordship, herein the Council again is not questioning upon the situation that we are in, that is the global pandemic COVID-19. Your Lordship, the whole contention of the Council herein is that the government is the parent patriae of the country. The government is the parent of the citizens, Your Lordship, and in such uncertain and such testing times, Your Lordship, the government is going on and breaching the data. The government is going on and handing over the data to a news channel. And then furthermore, Your Lordship, after doing that, the government is seeking immunity. Your Lordship, the petitioners, the people of the country just need an accountability and answer from the government, Your Lordship. The Council is not questioning the uncertain times, Your Lordship.
Well, my question is, what is the effect of Section 35 of the Disaster Management in the current scenario?
Most certainly, Your Lordship. Your Lordship, the Council is not well aware of what the Section 35 of the Disaster Management Act per se says. But Your Lordship, the Council would definitely be able to elaborate as to how Section 35 of the DPA is contended by the Council. Should you permit the Council?
Yes.
Much obliged, Your Lordship. Your Lordship, Section 35, like the Council contended, just provides an exemption to the government agency to process the data, which would ideally mean that all the provisions of the Data Protection Act, which actually acts as a...
I am not on the Data Protection Act, Council. I am on the Disaster Management Act, Section 35.
Your Lordship, the Council pleaded ignorance. The Council is not aware. The Council would seek permission to move to issue number 2 should that suit the court.
Just a minute. The two citations you gave, you did not. You gave the cause title only. You did not give the citations. Can you please give the citation? Supreme Court judgment, which year?
Your Lordship, in the argument.
Yes. You referred to two judgments. You have not given the citation. You have only spoken about the cause title. If you can please give the citation.
Most certainly, Lordship. Your Lordship, the first case that the Council relied on was the case Puttaswamy versus Union of India, which
That
was...
is 17, it's not. Then the other one, Narendra Kumar or something you referred to.
Yes, yes, your council. So the council would like to answer that it was enacted. It came in the year 1959. Your lordship. And when it comes to the citation, your lordship, should you give 30 seconds to the council?
Yes.
If your researcher has the citation, he or she can speak up.
Your lordship, the council shall address this concern in advance.
Next time, when you are referring to a judgment, please give the citation. That will be better instead of going by the cause title.
Absolutely, your lordship. Your
Then
lordship.
you can move to the second issue if other judges do not have any query.
Yes, please proceed. And just before you proceed, one short point is two wrongs don't make a right. So, you have to keep that in mind whilst you're alleging against the government. Please proceed.
Most certainly, Lordship. Your Lordship, the council would be dealing with the second issue in a twofold manner. It will try to establish, firstly, that the cobalt has moved beyond the ambit of the privacy policy and breached its term. And secondly, that the government's action was unlawful as it shared sensitive personal data to a news channel. Your Lordship, which led to unrest and turmoil in the country. Your Lordships, the Council would like to draw the bench's attention towards the principle of lawfulness, fairness and transparency mentioned under Article 5, Clause 1 of the General Data Protection Regulation of the European Law, followed by purpose limitation mentioned under Article 5, Clause 1, Clause B of General Data Protection Regulation. Furthermore, Your Excellencies, data minimalization, which is mentioned under, again, Article 5, Clause 1, Clause C of the Data Protection Regulation, and that the rudimentary principles of privacy and the most notable principles on personal data, privacy, and consent propounded, Your Lordships, have not been met in the instant case. Your Lordship, furthermore, the deleterious breach of the user's privacy is also a prima facie violation of Section 4, Section 5, Section 10, and Section 11 of Data Protection Act, Your Lordship, that propounds the obligations of a data fiduciary. Your Excellency, Section 4 propounds that no personal data can be processed by any person except for a specific, clear, and lawful purpose. Furthermore, Your Lordship, Section 5 proposes that the data that has been processed can only be for the purpose that is consented by the data principles. Your Lordship, should the court be kind enough to refer to the paragraph 4, Clause B of the privacy policy and the moot proposition, Your Lordships, there it has been clearly mentioned that the government shall carry out any in order to of medical and administrative interventions. There are two terms that have been used, Your Lordship: medical and administrative interventions. Your Lordship, nowhere has it been mentioned that the government is going to be using the sensitive personal data for a journalistic purpose or for journalism. So, Your Lordship, nowhere has it been given in the privacy policy. And Your Lordship, the government is contending that everything has been given in the privacy policy, and it is the responsibility of the data subjects to read it. However, Your Lordship, it has explicitly not been mentioned. And then your lordships, the data subjects go on to find out that one day on the news channel, their sensitive personal data is being broadcasted, which led to, Your Lordship, the people being thrown out of their homes. Your Lordship, the people being
Council, we would really request you to stick to the legal points. I can understand the emotion attached, but let's cut down on that and focus on the law. You have mentioned about GDPR. There are significant distinctions between the Indian Personal Data Protection Act and the General Data Protection Regulation. So unless you have something very, very specific to point to, don't generally ramble about it. Point number two is, you mentioned that there are some leeways which have been provided in the policy. You are interpreting those leeways not to be falling within the actions carried out by the government. Can you explain how this is not medical / administrative in nature, what the government has carried out?
Most certainly, Lordship. Your Lordship, the page 41 of the Data Protection Act talks about the objectives of the Act, Your Lordship. And in the objective of the Act, Your Lordship, it has been said that the objective of the Act is to promote concepts such as consent, limitation, data limitation, data storage limitation, and data minimalization. And Your Lordship, the same has been in the GDPR as well. So, and the objectives are also of the Personal Data Protection Act is the same. So, Your Lordship, the council was trying to just draw an analogy as to the.
So we clearly believe that there was consent. There is no two way about it. Do you have anything against, like, you have anything to refute that? Consent has been given. That's very clear.
Your Lordship, the council would beg to differ. Your Lordship, the consent of the users have been given for a medical and administrative intervention. And Your
So
Lordship,
therefore, my question was, how is it not medical / administrative? That's why I was leading you to that point.
most certainly, Your Lordship. Your Lordship, the government, if had to carry out really a medical and administrative function, when it launched Cobalt and when it told the citizen of the country to actually register, and that could be considered a medical step, and the users did that, Your Lordship. But Your Lordship, the users couldn't have apprehended that in the name of medical and administrative intervention, the government is actually going to take their data and give it to a news channel. Your Lordship, this step cannot be construed to fall under the ambit of medical and administrative interventions, because Your Lordship, the government is just.
Please proceed. I think we have got your point.
Most certainly, Your Lordship. Your Lordship, in the present situation, the very fact that Cobalt had assured its users through its privacy policy that the data sets will be processed by the company and by the government for medical and administrative function in a lawful manner. However, the sensitive personal data, Your Lordship, sensitive personal data is defined under section 3, clause 36 of the Data Protection Act, which includes financial data, health data, official identifier, the biometric data, and the other clauses like transgender status, intersex status. Furthermore, Your Lordships, and the government handed this to a news channel, which the repercussions, which the council would precisely call it as utter chaos and huge social predicament, Your Lordships. Your Lordships, it is humbly contended before this honorable court that the grounds of seeking consent ought to be very specific and very transparent, as mentioned under section 50 of the Personal Data Protection Act, having regard to whether the data principle can determine the scope of the consent in respect of the purpose of processing. Further, having clarity regarding having the clarity as to what they are giving their consent to, and this has again been reiterated under section 11 clause 2, and the capability of being withdrawn, that once the consent is given, there should also be a clause that talks about the withdrawal.
Counsel, two questions here. One is, what is the distinction between consent given for only personal information versus given for sensitive personal information? What's the distinction?
Oh, certainly, Your Lordship, the personal data has been defined under section 3 clause 20.
No, I know the definition. I'm asking a very specific question. You have less time, so please just respond to my query.
So, Your Lordship, personal data is just on the basis of identifying somebody. Very basic data, Your Lordship, name.
And no, I'm asking you, giving consent for personal information versus giving consent for sensitive personal information. How is it different?
You're absolutely, Lordship.
How it should be made different by the person who's taking the consent?
Most certainly, Lordship. Your Lordship, the ambit of what falls under the personal data and sensitive personal data is of utmost importance. Sensitive personal data has the health records of the individuals. That would include everything. And once somebody gives a consent to sensitive personal data, Your Lordship, that means
I don't think we are getting to the answer. Your time is up. Maybe you would like to seek a little more time to complete.
Yeah, most certainly, Your Lordship. So the council.
Okay. My second question to you is that under the Personal Data Protection Act,
I think his
yeah, sorry. Yeah, can you hear me now?
Yes, Your Lordship.
Sorry. So my question is that, sensitive personal data, can it go outside the country as per the PDP Act?
Your Lordship, the co-council shall be dealing with this issue, and the co-council is
any thoughts from your side on this? Can it at all go outside?
Your Lordship, it cannot be stored outside. the data mirroring that also happened in this, the primary data, the sensitive data should be stored in the country, while the backup and the other data can be transferred outside. But
Anything else from your side? I think we are good with this answer. Anything else from your side?
Your Lordship, if you could give 1 minute so the council can quickly wrap up with the.
Very quickly, 30 seconds. Thank you.
Much obliged, Your Lordship. Your Lordship, the government appallingly shared the sensitive personal data to the broadcasting network, which went in the public domain, causing immeasurable discord and unrest. The government did not subject appropriate safeguards and additionally subjugated all the rights of the citizens, like the right of access, right to rectification, right to restrict the processing. Therefore, be held wholly accountable for their actions and their clear omission of the duty of care arising out of the privacy policy contract. Therefore, Your Lordships, it is not only a grave violation of the internationally accepted standards and protocols with regard to privacy and consent, but also a clear and undoubted infringement and non-adherence towards the obligations that a data fiduciary owes to the data principles within the Act in consideration as well. Your Lordships, it was an honor pleading before this court. My co-counsel shall be dealing with issues 3, 4, and 5. Much obliged.
Thank you. Please proceed.
This is more for the timekeeper. Let the second speaker 25 minutes start now. Don't eat into that.
Yes.
And also one request. I don't know whether when speakers are speaking, whether they're able to see the timekeeper's time up sign. If not, maybe we can have some other mode of just calling it out. Maybe one of the judges can call it out, but it's better to just indicate very clearly to the speaker the time is up. Yes, sir. Sorry, Arindam sir, you were saying something.
No, it's all right. Because certain question answers were asked, so we can give the second speaker 5 minutes extra. Or,
Absolutely. Absolutely.
Greetings to the honorable bench. If your lordships do not have any preliminary concerns, council would like to assist this court onto issues 3, 4, and 5.
Right. Council, we understand that you are supposed to respond to the question on sensitive personal data. Can you address that first?
Absolutely, your lordship, to address your question first as to what difference there lies between with respect to consent to personal data and sensitive personal data. Your lordship, while section 11 is clear.
No, I'm not on consent. The question was regarding storage or transfer of personal,
absolutely,
sensitive personal data.
Absolutely. Your Lordship, council understands the concerns of this court.
Yeah.
Your Lordship, it must be noted that section 33, section 1 of the Data Protection Act of 2019 deals with the storage of sensitive personal data. Your Lordship, the verbatim is that the storage of sensitive personal data shall continue to be stored within the territorial limits of India in the Act, Your Lordship. However, Your Lordship, on an elaboration of issue 3, Your Lordship, council shall establish the same, Your Lordship.
No, I understand. And there's a specific reason why this bench is asking you this question. How are you interpreting this 33(1), regarding storage, whether it should go out? Yeah, can you just read and let us know how are you reading?
Your Lordship, there needs to be certain aids to such construction. Your Lordship, the first of which is a concept which is data localization, which is a established concept with regard to data protection and data privacy. Your Lordship, data localization essentially mandates that sensitive personal data and critical personal data as notified by the government must primarily be stored within the territorial jurisdiction of that particular country, Your Lordship. Given the present scenario, section 33 subsection 1 says that sensitive personal data shall continue to be stored within the territorial limits of India. With that, Your Lordship, while in the present case, a primary storage has been made in third-party cloud servers which are outside the territorial jurisdiction of India, which again involves a concept of data.
Sorry, Council, I will, for the benefit of everyone, I will read out 33(1). I will tell you what specific doubt I have. And why I am asking you this question is whether it is primary, whether it is secondary backup. I think that's a very tertiary or secondary tertiary question. How are you interpreting the section is more relevant for this bench? It says the sensitive personal data may only be transferred outside India for the purpose of processing. Subject to the conditions in subsection 1 of 34, the sensitive personal data may be transferred outside India, but such sensitive personal data shall be continued to be stored in India. Now, the problem that this bench is having is to understand, whilst it is saying that it can be transferred outside India, But in the very sentence, it is saying it shall continue to be stored in India. How are you interpreting it?
Because
Your
in your this problem, the main issue is that while it was being processed, the leakage took place. So you have to restrict yourself to that while you are referring to the act.
Most certainly, Your Lordship. However, Your Lordship must understand the fact that, Your Lordship, with respect to storage and storage in third-party cloud servers, Your Lordship, such cloud servers are prone to attacks. Your Lordship, the cloud server for Google, the cloud server for Apple was also prone to attacks.
Counsel, I think you are just spoiling your own case. So, I just stick to the legal question maybe, and then you can go on to your
Absolutely, Your
arguments.
Lordship. With respect to the interpretation of the same which Your Lordship had pointed out, Your Lordship, with respect to the storage of data, Your Lordship is absolutely right that the storage ought to be within the territorial jurisdiction of India, the primary storage at least.
Then what is transfer, Counsel?
Your Lordship, transfer is an aspect which comes under the ambit of processing of data, and such Your Lordship shall find mention of in section 3, subsection 31, which is defining as to what the processing of data with respect to personal data is, Your Lordship. With respect to transfer of sensitive personal data, Your Lordship shall find in section 34, subsection 1, there are certain qualifications that are needed. And if Your Lordship
Processing, processing, the definition of processing, I believe, also covers storage, right?
Absolutely, Your Lordship.
So
Absolutely.
then,
It is a holistic definition, Your Lordship.
so then how are you saying that it can be processed outside India? You are saying that it cannot be stored outside India.
Your Lordship, counsel is appearing for the respondents, and counsel is praying before this honorable court that not only can it be processed outside, not only can it be transferred outside India without valid consent, it can neither be stored outside India, Your Lordship. Your Lordship, the aspects of consent shall be dealt with further in the
No,
court.
I am. That's why I'm asking you the question. Are you saying that this can or cannot be sent outside India under any circumstance?
Your Lordship, with respect to sensitive personal data, it cannot be transferred outside India. However, Your Lordship, section 34, subsection 1 gives us certain situations as to and certain prerogatives and certain restrictions, keeping in mind of which such transfer may be allowed, Your Lordship.
You just mentioned that it cannot be transferred. This section, I have read it out for you. It is clearly stating that it cannot be it can be transferred, but it cannot be stored outside India, right?
Your Lordship, however,
so how are
this
you
section is with respect to a very particular clause. It is said that subject to the conditions in subsection 1 of section 34.
that's
If Your Lordship
that's
is
absolutely fine. Let's leave aside the conditionalities there. I'm saying how are you interpreting the word transfer, period? In a technical sense, in a techno-legal sense, when you are defining a word transfer, how do you see it? Is the data going out? And when you are transferring it, isn't it already residing somewhere else outside when you have transferred? And that essentially means it's stored there.
Your Lordship, may the council ask for a little clarification as to what Your Lordship meant when the last words fell from His Lordship's mouth?
So what I am saying is that the word transfer,
Hmm.
let's just pause there for a second and understand what is transfer.
Yes, Your Lordship.
This is not disclosure, counsel, that you show someone on something on someone's screen and just say you've just disclosed it.
Absolutely.
You're talking about transfer. Transfer means it is actually, and when you read the present day Indian data privacy and protection laws, there is a clear distinction between disclosure and transfer.
Absolutely. Your Lordship.
Right?
Absolutely.
Here we are not using the word disclosure, we are using the clear word transfer. So you are allowed to transfer, and then you are saying, however, it cannot be stored outside. So how are you looking at this whole word transfer is my short point.
Your Lordship, with respect to transfer in particular, it is basically if there is one entity A and another entity B, and A is having the data and A is giving to B, there is a probable transfer in this regard. However, Your Lordship, there is a clear distinction.
Are you agreeing that the storage has already taken place, therefore, when you have transferred it?
Your Lordship, the moment the data has been taken by the company Cobalt from the users, the storage is taking place, Your Lordship.
That means you're agreeing that the storage is taking place outside.
Absolutely, Your Lordship. And that
Right.
is what the petitioners are against, Your Lordship, that such storage outside cannot be allowed.
So as per your as per your interpretation, therefore,
Yes, Your
that the transfer and storage, it is one and the same. Is that correct?
Your Lordship, no, Your Lordship, it is not, Your Lordship.
Why not?
Essentially, because Your Lordship, transfer is a very specific term.
No, don't go by the term. You have to actually put it into effect, right?
Absolutely, Your Lordship.
Explain to us in specific, say a technical or a layman's term. How are you looking at it?
Your Lordship, transfer is essentially, given the present mood proposition, wherein the government is transferring the data to free public and free public is making it public.
Counsel, Counsel, I'm sorry to interrupt you. Once a transfer has taken place outside India to an ex-agency,
absolutely, Your Lordship,
doesn't it amount to storage, or will it be just hanging in the air, the data?
Your Lordship,
That's a simple question which you
there'll
need
be
to answer.
subsequent storage. Of course, there'll be subsequent storage. However, Your Lordship, transfer is the act. Your Lordship, storage is the destination of the data, Your Lordship, as to what is happening after the destination.
So therefore, we are back to our question. How are you reading 33.1?
Your Lordship, the Council is reading 33.1 in the way that Your Lordship, Council shall read out the section subject to the conditions in subsection 1 of section 34. The sensitive personal data may be transferred outside India. Transfer being that it may be sent outside India to another entity. However, such sensitive personal data shall continue to be stored in India. With regard to the section, Your Lordship, wherein there is a clear distinction between storage and transfer, these two words ought to have different meanings, Your Lordship.
No, that's why I'm asking you. You apply your legal mind and tell us the difference. I still could not get the difference.
Counsel, may I simplify? The question?
Most certainly, Your Lordship, most certainly.
Suppose X is an agency here, Cobalt. Now they are permitted to collect the data. Say it can be collected by your own volition, you are putting in the data. They are then collating it and making a data bank. Now for the storage, if the data bank, say the agency is keeping it within the territorial limits of India, if I have correctly understood you, then you say there is no breach of any of the statutory provisions. Now, at the same time, section 33 and 35, if conjointly read, for the purpose of transfer, it can go outside. The moment you allow the transfer and it goes outside, then there may be agencies who will be storing it outside the territorial limits of, say, India.
Your Lordship
Then it will amount to whether violation. That is the question I think was asked to you.
Your Lordship is absolutely correct. Thank you for the clarification, Your Lordship. Your Lordship, however, Council would like to establish that wherein such transfer and storage is taking place, the storage that is taking place is not primary storage, Your Lordship. It is subsequent storage. If absolutely, Your Lordship, section 33.1 is essentially dealing with primary storage, because Your Lordship, section 33.1 is vocative of the principle of data localization, which is a quintessential aspect into data privacy, Your Lordship. So data localization is mandating that the primary storage ought to be within the territorial jurisdiction of India. However, a backup may be stored outside, Your Lordship, with respect to such transfer, as Your Lordship has correctly pointed out, that storage is a quintessential aspect of such transfer. So as a backup or as a transfer, the data may be stored outside India. However, the primary storage must be within the territorial jurisdiction of India. Your Lordship, if Your Lordship may allow the council shall also substantiate this on the basis of the principle of data mirroring. Your Lordship, data mirroring, which is again a quintessential aspect of data localization. Your Lordship, data mirroring again says that the primary storage must be within the territorial jurisdiction. However, a mirror image of it or a backup of it or subsequent backups of it may be stored outside the territorial jurisdiction.
Council, whilst we are very happy to listen to you now, what we have to say in relation to your contentions. Two of the primary theories for which data localization is propounded by jurisdictions across the globe is trade theory and security theory. Trade theory says that my data, my oil, I want to use it the way I want it to be. Security theory is when the data should be housed in my country, so that I have access to it as and when I need it. Both these theories do not propound that a copy of that be stored outside, because this is a self-defeating argument otherwise. Okay. So we do not really agree with that. We can proceed now.
Much obliged, Your Lordship. While the Council understands Your Lordship concerns, however, Your Lordship, in the given case, the actions of the government were based on the aspect of the security theory, wherein the employees of Cobalt who were outside the territorial jurisdiction of India, it was quintessential for them to access such data. So for them to, for the easier access of such data, the backup was outside the territorial jurisdiction of India. However, Your Lordship, Council would like to, with the permission of this Honorable Court,
Please
Council would
proceed.
like to move on to subsequent
Please
arguments.
proceed. Yeah.
Your Lordship, with respect to the latter half of the principal argument of issue 3, wherein Your Lordship, that there is a failure to maintain necessary security safeguards as per the provisions of this Act, Your Lordship. Your Lordship, firstly, it shall be it is submitted before this Honorable Court that Section 24 of the Data Protection Act clearly lays down the reasonable security safeguards a data fiduciary or a data processor ought to take. In this regard, Your Lordship, uh, Cobalt happens to be a data processor. Your Lordship, however, there is no exemption to that fact that Section 24 can be done away with. Further, Your Lordship, it must also be noted that the fact that consent is a quintessential aspect over here. Consent needs to be read within two aspects, Your Lordship. Section 7 in a conjoined reading with Section 11, Your Lordship. Your Lordship, to address Your Lordship's question, which Your Lordship had rightly raised as to how there is difference in consent with respect to personal data and sensitive personal data. Your Lordship, with respect to personal data, Section 11 is clear that uh, uh, there needs to be clear consent, Your Lordship, explicit consent being the verbatim, Your Lordship. However, Your Lordship, with respect to sensitive personal data, a co-joint reading of sections 7 and 11 tell us that there needs to be free, fair, explicit, and informed consent, Your Lordship. In the given aspect, there is no informed consent, given the fact that the storage of sensitive personal data was in data servers outside the territory of India was conveniently left out of the privacy policy, Your Lordship. Further, the fact that the data was supposed to be shared with the Free Public News Agency was also conveniently ignored, Your Lordship. Your Lordship, again, transparency as per Section 25 is one of the quintessential to such policies, Your Lordship. Transparency is wholly lacking in this regard, Your Lordship. Further, Your Lordship, the fact that these are unprecedented times and for continuity of services, these provisions can be omitted, Your Lordship. This can not be the stand, Your Lordship. The Israeli Supreme Court has taken a stand to address the bench's concern. If Your Lordship may kindly pardon the Council for not being able to provide the citation because this is not yet reported. However, Your Lordship, the Israeli Supreme Court in the landmark case in the very year 2020, in the case of Mayor versus Prime Minister, had settled that the pandemic can be no ground for doing away with provisions of such scrutiny with respect to data protection, Your Lordship. However, the compliances must be uh, more acquainted and more complied with, Your Lordship. Further, Your Lordship, to establish as to how there was no free, fair, and informed consent, Your Lordship has already, the Council has already put forward before this court as to how relevant information was absent from the privacy policy. Further, Your Lordship must also note that free and fair consent under Section 7 and Section 11 both uh, give the right to the data principal to revoke such consent, Your Lordship. In the present case, there is no applicability of such provision, Your Lordship, given the sense that the data principal cannot revoke his consent, Your Lordship, and this is a blatant violation of the Data Protection Act, Your Lordship, a conjoint reading of Section 7 and 11, Your Lordship. If Your Lordship does not have any preliminary questions with
And
respect,
how do you know that there is no right of withdrawal of consent?
Your Lordship, the moot proposition is silent on that respect. Essentially, Your Lordship, because a notification under Section 35 has been issued that the government may process the data as it may deem fit, and such wordings is again vocative of the arbitrariness that is levied in that respect.
I'm
So, Your
sorry,
Lordship,
counsel, but this is the second time I'm hearing this. If there are certain conjectures, certain assumptions you're making, please make it clear before this bench that these are assumptions you're making. This is not there in the moot proposition.
absolutely, Your Lordship, there is no particular clause in the in the privacy policy as provided in the
Correct,
proposition.
because you have been provided an excerpt of the policy, right?
Absolutely.
So if
Further
it's
on,
not there, it's but fair for you to mention to this bench that you are assuming that there is no right of
Most certainly, Your Lordship.
withdrawal.
Council apologizes for such a such a backdrop. Further on, Your Lordship, it must also be noted that that Cobalt had already shared the particular data with the government, Your Lordship. Thus, even if there is a right of revocation, such won't take effect. And this is not a assumption, Your Lordship. This is mentioned in the very fact sheet, Your Lordship. Further on, Your Lordship, it is a fact that the data of 50,000 users have already been breached, Your Lordship. And Your Lordship, His Lordship, the Honorable Justice Chandrachud in the case of Puttaswamy versus Union of India, has been very kind to observe that data once gone can never be revoked, Your Lordship, in that regard. Further on, Your Lordship, with respect to issue 4, if Your Lordships do not have any preliminary concerns, Council would like to move to issue 4.
I believe you have 10 minutes, so you can. We will reserve our questions to a later point of time, possible.
Much obliged, Your Lordship. Much obliged. Your Lordship, issue 4 principally deals with the aspect as to how there is lack of separation of power within the authority formed under this act. The authority being the Data Protection Authority. Your Lordship, it must be noted that it is the same authority which is directing both the officers, which is the inquiry officer, as well as the adjudicating officer in this regard, which is manifesting the lack of separation of powers. Your Lordship, while the council recognizes that this honorable court has settled it as a matter of fact time and again that the separation of powers under the Indian preference is not rigid in its nature. However, if your lordships are kind enough to refer to paragraph number 37 of the memorial for the petitioners, your lordship, a very important observation has been made in that regard. Your lordship, in the case of IC Golaknath versus State of Punjab, wherein the obiter remains, your lordship, the citation being AIR 1967 Supreme Court 1643, and it had again been reiterated in the case of Dr. Ashwini Kumar versus the Union of India, which is yet to be reported. Thus, your lordship, the relevant information is miscellaneous application number 2560 of 2018, writ petition civil number 738 of 2016. Your lordship, it has been reiterated principally in this case, and I quote, that the logic behind this doctrine is not the strict classification. Rather, it is the avoidance of concentration of powers to a specific person or entity. Your lordship, in the given case, it is the central government who is appointing the Data Protection Authority. It is the Data Protection Authority in that regard who is appointing the inquiry officer. It is the Data Protection Authority again who is appointing the adjudicating officer. Your lordship, the central government, as per section 62, has direct role, and it is only the central government who is determining the jurisdiction, the manner of appointment, the terms and the functions of the adjudicating officer. In this regard, your lordship, there is too much power in the hands of the central government, your lordship. Further, your lordship, it is a quintessential. Again, your lordship, if it kindly refers to paragraph 41, wherein your lordship, this honorable court, in the case of State Bank of Patiala versus S.K. Sharma, the citation being 1996 3 SCC 364, your lordship, it has been observed that the evaluating officer should be a person with an open mind, and he should be able to hold an impartial domestic inquiry. Your lordship, given the structure of the Data Protection Authority over here, your lordship, given that all the members are from the same origin, your lordship, the central government has predominance in practically, not predominant, this is the only player in practically each and every aspect. It is impossible that a free and fair domestic inquiry will be held, your lordship. Further, this particular authority lacks the independence that a fourth branch on institution requires in this regard. Your lordship, further, the committee of experts under the chairmanship of Justice B.N.C. Krishna, whose report was instrumental in the drawing up of this bill, your lordship, has suggested the inclusion of the Chief Justice of India or one of his nominee with respect to the selection of the chairperson and the members of the Data Protection Authority. Your lordship, this has been done away with completely. There is no such inclusion of such authorities. It is only the government who is appointing the members. Your lordship, this in an extended sense is also a violation of the principle of natural justice, wherein, your lordship, the government is appointing the members, the government is controlling the jurisdiction of these members, and further, your lordship, these particular members are hearing out grievances against the government itself. Further, your lordship, even though the council realizes that the Data Protection Authority has multiple roles, investigatory roles, regulatory roles, adjudicatory roles, however, lordship, it must be noted that the adjudicating officer, whose principal duty is to adjudicate, is dealing with a very important aspect, which is the protection of fundamental right under Article 21. Your lordship, the right to privacy.
Council, we have a similar regime under the Customs Act too, or under the Income Tax Act. Absolutely. We have that similar regime under the PMLA also.
Absolutely, your lordship, council
also
understands.
And also many insurance acts where there is
Absolutely,
ombudsman.
Your Lordship, this Competition Commission of India, who is almost discharging similar duties as the Data Protection Act, also has such provisions, which Your Lordship has rightly pointed out. However, Your Lordship, kindly look at the duty, Your Lordship, even with respect, Your Lordship, in the present case, the adjudicating officer is looking into a fundamental right that has been breached, Your Lordship. If violation of the Data Protection Act is in turn a violation of Article 21 of the Constitution of India, Your Lordship, in this regard, parimeteria cannot be drawn with respect to the Customs Tribunal or the Income Tax
No, it is
Tribunal.
not customs tribunal. A customs, officer can conduct the investigation, raid a premises, conduct the investigation, issue a show cause, and his superior authority over whom there is administrative control is the adjudicating or the DC or the AC passes a order based on the show cause. He, in fact, the DC issues the show cause and adjudicates it after getting a reply from the SSC.
And they might be sitting in the same room.
Absolutely, Your
Yes.
Lordship. However,
And these
that-
powers have been held to be constitutional by the Supreme Court.
absolutely, Your Lordship. However, Your Lordship, given the present structure of the Data Protection Authority, Your Lordship, there is too much of concentration of power. Your Lordship, it is only the central government who is appointing. Further, Your Lordship, while the council accepts the fact that as Your Lordship had pointed out, what the process that underlies with respect to grievances under customs. However, Your Lordship, grievances under customs, they are statutory, they are breach of statutory provisions, Your Lordship. However, Your Lordship, with the Data Protection Act, it is something completely different, Your Lordship. The data protection, a violation of the Data Protection Act is in turn a violation of the right to privacy under Article 21, Your Lordship.
Council,
cannot
if
be-
an order, if I'm sorry to again interrupt you, if an order under, say, for I'm just giving the example of Customs Act, if the order under Customs Act is illegal, does it not infringe upon Article 14 or
Absolutely, Your
21?
Lordship. Absolutely, Your
The
Lordship.
same principle applies here too
Absolutely, Your
when
Lordship.
it comes to data privacy.
Absolutely, Your Lordship. In that case, the right of judicial review lies with the lies with the aggrieved person, Your Lordship. However, Your Lordship, what the council is contending at this point is the fact that the lack of separation of power is manifesting too much of power in the hands of in the hands of the central government. However, Your Lordship, further, the objective of the Data Protection Act is to protect the data principles. Further, Your Lordship.
Council, I think we have heard you on this. Two things. One is that there are enough and more examples. Okay, we have not even picked up SEBI, RBI, everything. All have the same construct, and in it is all past the muster. Can you give us one example where it has not passed the muster and therefore there had been a segregation?
Your Lordship,
that could have helped you actually. I was just waiting for that to come through.
Subject to correction, Your Lordship, Lordship, the novice knowledge of the council draws his attention to the case of Madras Bar Association, Your Lordship, wherein such segregation had taken place, Your Lordship. However, Your Lordship, while Your Lordship was absolutely correct in pointing out that the RBI and SEBI are such, however, Your Lordship, such bodies are fact-finding bodies, Your Lordship. The Data Protection Authority is not a fact-finding body.
Madras Bar Association dealt with the powers of tribunals.
Yeah, and also appointment.
Absolutely, Your Lordship.
Well,
Your Lordship, that shall be dealt with in the fifth and final.
You have 5 minutes for issue 5.
Much obliged, Your Lordship. Your Lordship, council shall move to issue 5, Your Lordship. Your Lordship, with respect to issue 5 is again an extension of issue 4, Your Lordship, wherein it has been ascertained that the power to perform adjudicatory functions being vested in an adjudicating officer who is not a member of any judicial body has led to usurpation of power, and the conferment of the same on the adjudicating officer is violative of such provision. Your Lordship, in order to establish this, as Your Lordship had correctly pointed out with respect to appointments, the Madras Bar Association has been the judgment of the Madras Bar Association has been very clear. Your Lordship, the tapping of a court has to be established in this regard, and the council shall do the same, Your Lordship. Your Lordship, it has been settled that mere legal proceedings do not ascertain are not conclusive tests for tapping of a court. However, Your Lordship, given the structure of the adjudicating officer over here, Your Lordship, it must be noted that, Your Lordship, the adjudicating officer is determining something with respect to the Data Protection Act, Your Lordship, which is in turn an extension of Article 21 of the Constitution of India, Your Lordship. Further on, Your Lordship, it must be noted that the adjudicating officer also has the powers of a judicial authority in this regard, wherein, Your Lordship, he or she has been conferred with the rights to summon and other powers that a civil judge has, Your Lordship. In that regard, Your Lordship, it is also noted that in the given case, Your Lordship, while under Section 62, the independence is one of the quintessential factors for the functioning of an adjudicating officer, Your Lordship. Given the present structure, Your Lordship, given that even if Your Lordships are kind enough to refer to Section 46 of the Data Protection Act, Your Lordships would find that even the removal of the members and the chairperson of the Data Protection Authority, Your Lordship, can be as per the whims and fancies of the government, Your Lordship. So, in order to safeguard such issues, Your Lordship, a judicial mind is needed, Your Lordship. The essence of a judicial officer becomes quintessential in this regard, wherein the aspect for expertise the council takes note of. However, Your Lordship, the aspect of to hold an impartial inquiry can only be done under such subjugation of power only if it is a judicial officer in that regard, Your Lordship. This has also not been complied with, Your Lordship, in the Data Protection Act, less the fact that the recommendation of the Justice Sri Krishna Committee has been left out, wherein, Your Lordship, it has been mandated that that the inclusion of the Chief Justice of India or his nominee be there in the appointment of such officer. Further, Your Lordship, in the case of...
Are you challenging the constitutional validity of any of the provisions of the DP Act?
Most certainly, Your Lordship. Your Lordship, the council is challenging Section 62, which deals with the appointment of the adjudicating officer, Your Lordship, the structure of the adjudicating officer. That was the core essence of issues 4 and 5, Your Lordship.
Isn't 4 and 5 challenging the notification, or was it
No.
challenging the
Your
very
Lordship,
act?
not the very act, Your Lordship. Section 62, which is dealing with the appointment, and the corroboratory Section 63, which is dealing with the functions of the adjudicating officer in that regard, Your Lordship. Wherein, Your Lordship, council has submitted before this honorable court that it is a violation of Article 50 of the Constitution, essentially because there's too much concentration of power in the hands of the central government, Your Lordship. Further, if Your Lordship is kind enough to refer to the case of State of Gujarat versus Utility Users Welfare Association, Your Lordship, the court has mandated that at the set of final trial or the stage of final hearing, Your Lordship, the mandate of the presence of a judicial officer is quintessential. Again, Your Lordship, with the adjudicating officer is the officer as in the Data Protection Authority who is having the final word with regard to adjudication, Your Lordship. And while Your Lordship is council accepts the fact that the expertise is one of the factors, the judicial mind is also required, Your Lordship. Thus, the training of a judicial officer is quintessential, Your Lordship, in this regard.
Well, I have only one question.
Yes,
If you
sir.
go back to issues 4 and 5, and if you read them slowly, can you tell them whether it challenges the virus of the act or whether there is challenge to the power per se?
Your Lordship, Section 62 is dealing with the appointment of the adjudication officer.
My question is very simple, Speaker. If you read issues 4 and 5 slowly, as
Yes.
given in the mood problem,
Absolutely.
can you tell us whether only the power is being challenged or the virus of the act is being challenged there?
Your Lordship,
The question is
the
more on
categorical
your
answer is-
the question is more addressed to your understanding of how the issue is being framed.
Most certainly, Your Lordship. Your Lordship, on a categorical scale, the powers are challenged. However, Your Lordship, Council would also like to make a submission that the powers are enshrined under a provision of the Data Protection Act. So it is in turn that particular provision which is being challenged, Your Lordship.
But what about your prayer? Your prayer speaks otherwise.
Your Lordship, the prayer, Your Lordship,
It's confined only to the notification.
most certain, Your Lordship, if Council kindly draws your attention to the to page number 36, which has the prayer, Your Lordship, for the memorial for the petitioner, Your Lordship. Your Lordship, there's a five-fold prayer, Your Lordship.
Okay.
If Your Lordship's permit, Your Lordship's Council shall proceed on to the prayer and read out the same, Your Lordship.
Fine, proceed with your submissions, please.
Most certainly, Your Lordship. Thus, it is, Your Lordship, finally, it is also submitted as an extension to issue 5, Your Lordship, that while your lordship, this is a preemptive rebuttal to what the respondents might come up here and say, your lordship, given the fact that there is a provision for a statutory appeal to an appellate authority, there is provision for a statutory appeal to the Supreme Court. Your lordship, there is a provision for judicial review, your lordship. However, your lordship, even though there is such provision with respect to the appellate authority, your lordship would again be startled to find that as per section 67, it is only and only the central government. Your lordship, council will be wrong if council says that there is executive predominance in such appointment. Your lordship, it is only the members of the executive and only the members of the executive who are appointing even the chairperson and members of the appellate tribunal, your lordship. Your lordship, again, the BNC Krishna committee had stressed upon the fact that at least in the appellate tribunal appointment, the inclusion of the Chief Justice of India or his nominee ought to be there. However, your lordship, this also has been conveniently ignored, your lordship. Your lordship, with that, the council would like to stress upon the fact that, your lordship, it is no argument that justice can be denied at a particular stage just because there is a provision for appeal, your lordship. Thus, your lordship, the entire
No,
structure.
but appellate provisions to the appellate tribunal as well as to the Supreme Court are sufficient safeguards.
Absolutely, your lordship. While your lordship council is recognizing that there is statutory appeal to the Supreme Court, your lordship council is also recognizing that there is right of judicial review. However, your lordship would be kind enough to look at the appointment of this particular appellate authority, your lordship. Your lordship, the appellate authority is again, as per section 16, is wholly appointed by the central government, your lordship. Your lordship, the Justice BNC Krishna committee has been categorical in this regard to recommend that the inclusion of the Chief Justice of India or his nominee ought to be there. However, lordship, there is not only executive predominance, it is only the executive who is appointing in this regard, your lordship. Thus, your lordship, this does not satisfy the principle of separation of powers, your lordship. Your lordship, given that the council's time is up, council would kindly, your lordship may kindly grant permission to the council to move to the prayer, your lordship.
Well, we are quite aware of the prayer, unless any other, my fellow judges have any questions for you for that 1 minute.
No, nothing else from my side.
Yes, nothing also from my side. Let us come with questions if required after completion by the respondent.
Most certainly, your lordship. Most certainly. It was an honor leading before this one. Much obliged.
Thank you.
Greetings of the day. The council seeks permission to address the bench collectively as your lordship.
Yes, please.
The council today represents the respondent in the case of body of individuals versus Government of Zindia and Cobalt. The council 1 shall be dealing with issue 1 and 2 for approximately 25 minutes, and the council 2 shall be dealing with issue 3, 4, 5 in that order for rest of the 25 minutes. The council seeks permission to start with issue 1.
Yes, please.
Your lordship, the first issue before this honorable court is divided in 3 limbs. Whether the notification lacks force of law, whether the notification is unfair and unreasonable, whether the notification fails to satisfy the test of imposing valid restriction on the fundamental right to privacy. Your lordship, addressing the first limb, going by Article 13, Clause 1, Clause A of the Constitution, which defines law as including any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. In Sripat Amit Dange versus Sir Harsit Bhai V. Divetya, it's a Bombay High Court judgment, year 1947, it was observed that the definition of law includes an order made by the competent authority, a bylaw passed by statutory authority competent in that behalf. Further, in the case of State of Bombay versus F.N. Balasara and others, Bombay High Court again observed that an order made by the government in the exercise of power conferred under a section owes its legal efficacy to that section, and therefore, in the eyes of law, the notification or such order has the force of law as if it is made by the legislature itself. Your lordship, since the notification in the given fact situation was issued under section 35 of the Personal Data Protection Act, it can be said to have the valid force of law. Moving to the second.
Sorry, counsel, you would have heard brother counsel, judge before. When you are citing a case, please give the citation as well.
Yes, your lordship. Sripat Amit Dange versus Sir Harsit Bhai V. Divetya, 1947-49, Bombay Law Reporter, page number 468. Second case being State of Bombay versus F.N. Balasara and others, 1951. 53, Bombay Law Reporter, page number 1982. Your Lordship, addressing the second limb, the notification is not unfair and unreasonable. As in the case of Kasturi Lal versus State of Jammu and Kashmir, the Supreme Court, the citation being 1980, SCR, Volume 3, page number 1338, the Supreme Court had observed that there is always a presumption that the government action is reasonable and in the public interest. And it is for the party challenging it to show, and it is for the party challenging its validity to show that it lacks the reasonableness. And that is a heavy burden. The court must be satisfied. Your Lordship, I seek apology. This burden is a heavy one and it has to be discharged to the satisfaction of the court by proper and adequate material. The court cannot lightly assume that the action taken by the government is unreasonable and would not strike down governmental action as invalid on this ground unless it is satisfied that the action is unreasonable. Your Lordship, by deciding the test of reasonability as given in the case of Chintamani Rao versus State of MP and Mohammad Hanif Qureshi versus State of Bihar, the citation of Chintamani Rao versus State of MP being 1950 SCR 759, a citation of Mohammad Hanif Qureshi versus State of Bihar being 1959 SCR 629, page number 629. The test of reasonable involves prevailing conditions aspects like prevailing conditions at the time, evil sought to be remedied, and the urgency of such an action. Your Lordship, despite the world's overwhelming preoccupation with COVID-19, the threat of domestic and international terror is not in the decline according to the available indicators. The situation of pandemic is being exploited by terror organization for the spread of conspiracy theories aimed at to fuel hate against the government and to encourage hate against the minority groups. This was identified by a UN report titled Impact of Pandemic on Terrorism, Counter-Terrorism, Countering Violent Terrorism. Your Lordship, in the given fact situation, Your Lordship may refer to para 5, page 3 of the fact sheet. Immediately before the issuance of notification, there was a certain event where certain social media posts were circulated which targeted a certain minority groups that later on led to their lynching. Your Lordship, the fact that it led to their lynching means that these terror organizations somehow had the access to the health data of the users of Indian citizens. Your Lordship, this can be linked with misuse of certain mobile apps available for stealing and surreptitiously transmitting user data in an unauthorized manner to servers located outside India. Your Lordship,
Counsel, sorry, I'll pause you for a few seconds here. The issue and the action carried out really does not match up, right? If there has been a concern of this nature, you preparing a compendium of everything and circulating to everyone, is that a solution at all? What did the government have in mind?
Your Lordship, the government wanted to ensure that the personal data sets that users provide to any app that users are using are not surreptitiously transmitted outside India. Because
so you make it public?
No, Your Lordship. The notification made the provisions of the app inapplicable to the processing of personal data sets by the government. So the government wanted to process.
What did the government do, Counsel? What did the government do?
Your Lordship, that part is dealt in issue 2.
It does not matter. I'm asking you a question. What did the government do when it came across such a situation, such hatred being spread? What did it do? It prepared a compendium, right?
Indeed, Your Lordship. Your Lordship, in this case, the government wanted to process the personal data set so as to ensure that there is no leakage of such data outside, because then it will threaten the very sovereignty.
Counsel, I don't think I'm able to get the answer from you. Please understand what I'm trying to say. If you have an issue at hand, you have a plausible cure to it, you trigger it, you can argue for that. I'm happy to hear you on that, right? But if you have an issue like this, where there has been hatred, there has been lynching all around, you prepare a compendium of all people who are infected and you publish it?
No, Your Lordship. The publishing of data that took place via Free Republic, the news agency, the only data that was published was name, location, and health data. It was done so as to make people aware if they have, so that people can take safety measures and not get infected further due to the coronavirus.
It is still not matching up. Have you realized that?
Your Lordship, the step that was taken by the government as per the notification was to ensure that security of the state is not under threat.
How is security not under threat when you're doing such an act?
I'll just put the same question in a different perspective. You keeping one section of the public safe, as in the minority group, is a prerogative, and it's imperative that you keep them safe. Agreed. However, it does not mean that the 2, 3, 4, how many ever millions who are affected are being published on a yellow pages, and that list made being public for the non-COVID persons to pinpoint fingers and make them being looked down in the public. So they are being looked at as outcasts. So my fellow judges' question is, how do you undo the consent and make them really, they are actually victims.
Your Lordship, there was a necessity for that sort of action.
First, they are already infected, so they are victims from the virus. And they are victims by the government's act by being showcased as though they are, anyway, you complete my thought.
Your Lordship, the action of releasing the data, disclosing the data to the public was very well covered. When we look at the definition of processing, it covers disclosure, making available, and transmission. Your Lordship, under Section 12 of the Data Protection Act, the requirement of consent can be done away with while responding to a natural disaster or medical health emergency. Your Lordship, the government took this action because there was a necessity of such action. There was a data breach by Cobalt, which meant that the government had to come up with other alternative to make people aware that they do not come in contact with such COVID positive patients. Your Lordship, in Angana Kumar versus, this is a Odisha High Court judgment, Angana Kumar versus Union of India, the court observed that any such disclosure needs to pass the triple test of privacy. The three tests being existence of a law, legitimate aim, and proportionality. Lordship, there was a law to back this action, that is Section 12 of the PDP Act. Further, there was a legitimate aim of protecting public health. And thirdly, proportionality includes the aspect of necessity of such an action. And this action was needed at that point of time. And further addressing that people face stigma, Your Lordship, there is always a risk of ostracization since coronavirus is a contagious disease. Like government has been, even if your own family member contracts such a virus, it is advisable that you maintain distance from them.
Counsel, if I may pause you for a moment, what was the Orissa High Court decision dealing with? What was the issue?
It was a PIL by a lawyer named Angana Kumar. It was for disclosure of COVID positive patient names. So the court held that it should pass the triple test of privacy, and while in the real world there is no PDP Act as such, therefore there was no existence of law.
Has that been circulated?
Your Lordship,
the copy of the judgment, has it been circulated in the compendium?
Your Lordship, I would require the help of the researcher to answer this question.
Okay, the researcher says no.
Right. Also, counsel, did I just hear you that there is no present day law?
Your Lordship, by dealing with this question, whether disclosure of COVID patients' name could happen, the court said that triple test of privacy needs to be passed. And
no, my question is very pointed to you, counsel. Do we have or we not have a law today to handle a situation like this?
As per the moot proposition, we do have.
And what is the law that we have today? No, not the PDP Act. I'm saying that aside from the PDP Act, do we have anything?
Your Lordship, if we rely on Disaster Management Act Section 73, exempts
Something
and
specific to data, because that is the point that we are mooting right now.
Your Lordship, I no, Your Lordship, I would rely on PDP Act itself as per the moot proposition.
No, I understand what you're relying on, counsel. That's absolutely fine. I'm saying that aside from the PDP Act, is there anything, any other law which is specifically talking about data privacy, data protection, personal information, sensitive personal information of anything of that sort?
Your Lordship, there was SPDI rules given under Section 43, but Section 43 has been, after PDP Act, it has been overruled. Section 40,
Is it only section 43, and that is not 43, that is 43A?
43.
Is it 43A
yeah,
and the SPDI rules? Are these the only two provisions that are there? Is there any other section that is there? And I'm giving you some further hint. Is there any other section in the IT Act which is still alive as we are speaking, assuming the PDP Act is alive?
Section 8, Your Lordship. Section.
Please proceed. Please proceed.
Um, Indeed, Your Lordship. Um, Addressing issue 1, second limb. There's a, Your Lordship, I would require a minute.
Sure.
Addressing the third limb, whether the notification satisfies the test for imposing a valid restrictions on the fundamental right to privacy. There are 3 tests, that is existence of a law, legitimate aim, and proportionality. Since this notification was issued under Section 35 of the PDP Act, such order, there is an existence of a law. Further, Section 12 allows the government to process the data without consent while responding to any medical health emergency. Secondly, there was a legitimate aim, as in the case of K.S. Puttaswamy. The court expressly cited that national security as a legitimate state interest where the state may have justifiable reason for collection and storage of data. Hence, national security is a legitimate aim. Thirdly, the third test of proportionality, Your Lordship, as per the EDPS's guide on processing personal data, it says that if a provision is not proportionate, certain things like sunset clause and expiry terms can be introduced. Lordship, in this notification, it is very categorically said that this notification is being brought out because terror organizations are exploiting the situation of pandemic to cause riot and panic, which clearly there's an implicit sunset expiry term to this notification. As soon as the pandemic is over, this notification will not have any force of law. The respondent side is ready to give an undertaking with regard to the same, which also brings it makes the notification proportionate. If Your Lordship is satisfied, the council would proceed to the second issue.
Yes, please.
The second issue is whether Cobalt sharing the personal data sets with the government and the government sharing the personal data sets with Free Republic was in breach of the terms based on which consent was given by the users and in violation of the terms of the privacy policy. Lordship, clause 2 of the notification on page 4 of the fact sheet required Cobalt to share the data. It was very categorical that Cobalt had to share the personal data sets with the government. The notification, as said, was given under Section 35 of the Act. The explanation clause 2 of Section 35 says that the expression processing includes sharing of data with government by any data fiduciary. Your Lordship, it was binding on Cobalt since the notification was issued pursuant to the Act. Thirdly, Your Lordship, Cobalt had no obligation to take consent as notification exempted application of those rules, Section 11, that required taking explicit consent. Fourthly, Your Lordship, clause 2 of the privacy policy, the users had consented and they had knowledge that such data may be used by government for carrying out medical and administrative intervention. Lordship, as per the legitimate expectation of privacy, it can be said that while handing over the personal data sets to the Cobalt, the users had some expectation that in case we test positive, such data may be shared by the government. So it was not completely alien of a concept for them. Further, Your Lordship, addressing the second limb, whether such data could have been shared by to the Free Republic, Section 12 says that such requirement of consent can be done away with to provide assistance in a natural disaster. Notification dated 24th March declared that COVID-19 situation falls under the category of a disaster. The very definition of processing in Section 3, subclause 31 includes disclosure by transmission, dissemination, or otherwise making available. Therefore, the government had such right to take such action of disclosing such data. Thirdly, government had the right to create awareness to provide assistance under Section 12, as mentioned already. Further, Section 4 of Epidemic Disease Act and Section 73 of Disaster Management Act exempt action taken by the government in good faith. Here in the
Council,
given...
again, I'm interjecting you. What is the effect of Section 96 of the DP Act?
Your Lordship, it has an overriding effect if any law is contrary to the Personal Data Protection Act.
So, won't that come against you?
No, Your Lordship, because Section 73 permits the government to take any action in good faith while there is a disaster.
There is also a similar provision in the Disaster Management Act too. Then which one would prevail?
The Personal Data Protection Act, because here we are primarily dealing with the personal data.
So won't that go against you as a state?
No, Your Lordship, it wouldn't go against the state.
There is an overriding effect under the DM Act. There's an overriding effect under the DP Act. Which one would prevail?
Your Lordship, since...
the recent one would prevail or the latter will prevail, or is it harmonious construction? What do you look at it? And how do you look at it?
Your Lordship, Council would, since the Council is dealing with the provisions of this Act, the Council is of the opinion that Section 96 would prevail. And it is for the Honorable Supreme Court to adjudge which section would prevail.
Council, is there some principle of statutory interpretation here that would come, if you are aware of, or else I would not torture you extracting some answer on it?
No, Your Lordship.
Okay, fine. Please proceed.
Is the council aware of right to be forgotten?
Yes, Your Lordship.
Wouldn't that apply to me even before you went ahead without my consent? I'm speaking for the petitioner for a minute. That even without my consent, you have possibly eliminated the possibility of my travel abroad, visa processing, my access to employment, everything. I mean, how do you address that?
Lordship, there's a very specific provision under PDP Act that says that users can withdraw their consent for continued disclosure of their data. Your Lordship, since there was a pandemic going on, Cobalt did not have that opportunity to provide that consent. While saying, well said that, the respondent side also says that once the situation of pandemic gets over, the Cobalt would update its privacy policy and would give such an option to the users if they would still want to continue sharing their data with Cobalt or not.
Council, do you realize what you just... Sorry, Bharat, just give me 1 second here. So did you realize that how you killed your case? You've actually admitted that you have not given a right of withdrawal.
Your Lordship, in this case, Section 7 of the... All right, Lordship, Section 35 of the Act makes the provisions of that inapplicable to such processing. Therefore, we would take shelter under that.
No, so I heard you. So it's the same question which Judge Supratim had asked. Now that you have published a digital yellow pages, and once anything is published on the digital world, it's going to be etched in digital world forever. And that's why I asked you the question of right to be forgotten. Once the pandemic is over, once the consent, I have the ability, or the petitioner has the ability to withdraw the consent, how will you undo the published permanent digital yellow pages?
Your Lordship, the news agency with whom the data was shared can be the news agency can be asked to delete that data with the standard procedure of deleting of such data. And Your Lordship, with regard to the fact that the data was released in public, yes, Your Lordship, once an information is in the public, it cannot be deleted as such. But Your Lordship, since this was an unprecedented situation, such action had to be taken from the state's end. Since the state also had a constitutional obligation to safeguard right to health, which is also a part of Article 21 of the Constitution.
So do you mean to say that you're acting in public interest?
Yes, Your Lordship, we are acting in public interest.
Because is it because I've given you that clue that you're saying that you're acting in public interest, or is it somewhere in your memorial which you state so?
Your Lordship, we have stated in the memorial two cases that I would like to say here. I do not have the citation in my script.
We believe that this government has acted in public interest, except the public which forms part of the petitioners.
Your Lordship, according according to Article 8 of European Convention of Human Rights, interference in a privacy by public authority could be justified in the interest of national security, public safety, or economic well-being. This action was taken and for public safety.
Council,
and this is
fantastic. So Bharat spoke about right to be forgotten. You brought in a European angle to it. Let me ask you a related question. How is right to be forgotten different under the PDP Act versus what is written in the European Union General Data Protection Regulation? Perhaps that will help you slightly to take care of Bharat's answer.
Your Lordship, the Council stated the Human Rights Convention.
I'm talking about the EU GDPR. The GDPR versus our PDP Act, and you have a clear indication in the memorial that you can fall back on similar jurisprudence. The mother of such jurisprudence is right now the European Union General Data Protection Regulation. So can you give us any hint of how right to be forgotten is slightly different? And perhaps there is a slight bit of hint for you or help for you, what Bharat is asking.
Your Lordship, the Council seeks permission to take the help of a researcher.
Right. So whilst we are listening to your other speaker, you have to read up two things. One is Section 72A of the Information Technology Act, and this particular distinction between GDPR and the Indian PDP Act on right to be forgotten. So if you're okay, then we can proceed to the second speaker.
Much obliged, Your Lordship.
Greetings of the day, Honorable Bench. The Council seeks permission to address the bench collectively as Your Lordships.
Yes, please.
Sure. Just switch on your video, please.
I think it's on.
Yeah, indeed, Your Lordship.
Okay.
Is there a, sorry, I think, I thought that the instruction was to make it full screen or something. Is there a modality to?
Your Lordship, you have to go, you have to choose the gallery view.
Yeah, she's got two
devices.
logins.
Indeed, Your Lordship.
One is the audio, one is the video.
Indeed, Your Lordship.
Okay.
Your Lordship, the Council shall be dealing with issues 3, 4, and 5 in the said order. Your Lordship, the Council seeks permission to proceed with issue 3. Much obliged. Your Lordship, issue 3 is primarily divided into two limbs. First is whether the transfer of sensitive personal data to a third country is in violation of the provisions of the Act. And second, whether Cobalt's failure to provide security safeguards while the data was being transferred is in violation of the Act. Addressing the first limb, Your Lordship, Cobalt is in compliance with Section 33, Clause 1 of the Act, which provides that the sensitive personal data can be transferred to a third country if one copy of such data sets are being stored in the country itself. Your Lordship, referring to the facts on point 4, page 2 of the fact sheet, a copy of the data was stored in the Indian territory itself.
The next country. Sorry, Council, I'm extremely sorry. Where is this one copy thing written in the Act?
Your Lordship, Section 33, Clause
Yeah.
1. Your Lordship,
Can you
Section
read?
33, Clause
Can
1.
you read that part where it is saying that one copy has to be written?
A copy has to be retained in the country, and the transfer is allowed.
Yeah, please read out that portion to us. We'd like to hear that particular section.
Much obliged. Much obliged. Sincere apologies, Your Lordship. Just a second. Your Lordship, Section 33, Clause 1 of the Act reads as, subject to the conditions in subsection 1 of Section 34, the sensitive personal data may be transferred outside India, but such sensitive personal data shall continue to be stored in India. Your Lordship,
Now,
which was...
we're back to that same section, if you observe, and you are conveniently interpreting it to mean a data mirroring provision, right? Now, if it had been a data mirroring provision, it would have been worded differently. I at least cannot read this to say that a copy of this, if kept in India, is good enough. It is clearly stating that it has to be stored in the country. There is no mention of a copy of it being kept in the country, and that is good enough.
Your Lordship, the personal data sets were stored in the country as well, and one copy was being transferred to a third country. Your Lordship, further it subjects the data fiduciary and data principle to Section 34, Clause 1 of the Act, which makes explicit consent a necessary requirement before transferring such data. However, Your Lordship, the government and...
Sorry, I am still not getting my answer, Counsel. Please understand what I'm trying to drive home, right? Why does a government say, please do not take this data out of the country, right? Because there are no multiple channels open, say in a different jurisdiction, where a foreign regulator, foreign authority can look into such data. Now, the moment you are saying that one copy is stored in India or one copy is stored outside, that means you are opening that window right away there, right? So there is a problem. I'm not unnecessarily harping on this point. The moment you are stating this, you are actually creating a very big lacune.
Your Lordship, as per the facts of the case, it is clearly stated. It is clearly stated in Part 4A of the fact sheet that by storing a copy in the Indian territory, Cobalt has complied with Section 33, Clause 1. Your Lordship, it is only according to the facts, and the Council is not putting up assumptions.
Therefore, my question to you, Counsel, is what is your interpretation of 33.1? That is why I made you read it, right? Please let us know, how are you looking at 33.1?
Your Lordship, the Council is sticking to the facts of the case, wherein it is clearly stated, it is given that the Cobalt has complied.
Counsel, I have no problem in you sticking to the facts of the case. I'm asking you a point of law. You read 33.1. Now you tell me, what is your reading of this particular subsection?
So my fellow judge is asking a simple question on what is the difference between stored in India and technological difference between stored in India and transferred outside India.
Your Lordship,
that's a technical question.
Indeed, much obliged to the question, Your Lordship. The council holds a view that when it's given that the data is being transferred, it is implied in that proposition itself that it is being stored also. The two terms are not isolated according to the council's opinion. However, the council will continue to humbly submit that the government and the Cobalt are very much in compliance with the act itself, which is the issue, Your Lordship.
Please
was
proceed.
about the...
Thank you. Please proceed.
Much obliged. Your Lordship, having said that, the further requirement for transferring sensitive personal data sets to a third country was to obtain explicit consent of the data users. Your Lordship, however, the government and the Cobalt are immune from this. They are exempted from this obligation because of Section 12 of the Act. Your Lordship, Section 12 stipulates conditions, rather exemptions, under which data can be processed without obtaining consent of the data principals, and conditions under which, under Sections 12 Clause D, 12 Clause E, and 12 Clause F are fulfilled in the following situation, in the given situation, Your Lordship. Your Lordship, Section 12 Clause F reads as, data can be processed without obtaining consent of the data users if it is in order to undertake any measure or to ensure ensure safety of or provide assistance or services during any disaster, any outbreak of disease or public order. Further, 12E reads as, it can be done to undertake measures to provide medical treatment or assistance or health services during outbreak of disease, which clearly, your Lordship, is the case. It is happening in the case. Referring to facts on point 4, page 2 of the fact sheet, Your Lordship, clearly the processing was done to assist the citizens by letting them protect themselves against contracting the virus, and by providing doorstep delivery of flu-related drugs. Further, a copy of data sets, as the council already submitted, that it was being stored here, thereby complying with Section 33 Clause 1 of the Act. Therefore, by transferring sensitive personal data outside this Indian territory, these sections are not violated, Your Lordship. Addressing the second limb, Your Lordship, addressing the second limb on page 10 of the memorial, Your Lordship, under normal circumstances, Cobalt, as a data fiduciary, was under an obligation to provide security safeguards to the data under clause 7 of the under clause 2 of the privacy policy, for which Your Lordship may refer to Part B, page 3 of the memorial of the fact sheet. However, the council humbly submits that clause 7 of the privacy policy exempts Cobalt from the obligation, as COVID-19 was declared a force majeure event via notification of Ministry of Finance dated 19 February 2020, which Your Lordship may refer to on point 3, page 2 of the fact sheet. Moreover, Your Lordship, Honorable Delhi High Court in Halliburton Offshore Services versus Vendetta Limited, footnote number 19, page 10, for the citations, Your Lordship, opined that the country in a nationwide lockdown and the outbreak of COVID-19 disease was a prima facie in nature of a force majeure event. Further, Your Lordship, this clause clearly intends to save the performing parties from the consequences of anything over which he has no control, which was also affirmed in Kedar Tall Steel versus Hari Tall Steel for the citation.
Council in Halliburton was not given the benefit of FM, force majeure there, despite of this observation.
Your Lordship, the council is relying on its observation.
Have you
that
gone through the facts of Halliburton judgment?
Sincere apologies, Your Lordship.
But ultimately, they did not get any benefit of FM there.
Your Lordship, however, the Honorable Court gave the reasoning that the main intent of the force majeure clause is that to protect the parties against anything they had no control over. Your Lordship, the data was transferred on a real-time basis. Your Lordship, if the Cobalt would have indulged itself in creating security safeguard mechanisms, etc., the servicing of the app would have stopped, which would have caused more harm than good. In such desperate situations, Your Lordship, the Cobalt did what was under the company's control. Thereby, Your Lordship, it's a submission that it's immune under clause 7 of the privacy policy, thereby not violating any provisions of the act.
So you mean to say that Cobalt should have just exercised reasonable efforts to protect it, and if it cannot, then it is free to do it.
Sincere apologies, Your Lordship. Your Lordship, the council's submission is that Cobalt was not in a position to implement any security safeguards at that time, because the world was in a lockdown situation, and the employees of the Cobalt were allowed to work from their take-home devices. In such a situation, and Your Lordship, more importantly, there was lack of time. Therefore, weighing the events that would have resulted in more harm, because if there was a mechanism implemented at that
Is
time,
it a reasonable defense? Is it a reasonable defense?
Your Lordship, the defense of force majeure is pretty much reasonable. That is on which the argument is based, Your Lordship. The council humbly submits that.
Okay,
Yes,
if just sorry, any
council,
Much
question?
obliged.
council, my question will be, see, there is two latches if you go by the moot problem. One, the government publishing the data, and while COBOL storing the data or transferring it had allowed the leakage. Now, whether it is leakage intentionally or without safeguard, that is a different question altogether. Now, tell me, in such situation, what safeguards on behalf of the government you may suggest? Because this is not a unique problem. It may happen even during the time when the pandemic is not there. Is there any suggestion from your side? It's not
Your,
within the moot problem, but any suggestion from your side?
Much obliged, Your Lordship. Your Lordship, in normal circumstances, as the council submitted already, the data fiduciary as well as the data processor have a responsibility to provide necessary security safeguards, such as use of methods such as de-identification and encryption, and take necessary steps to protect the integrity of personal data, take steps to prevent misuse, unauthorized access, and modification or disclosure to such data. Your Lordship, these conditions are provided under Section 24, Clause 1 of the Act.
No, this act provides for, but referring to this problem, these safeguard measures, if had been taken, then this problem would not have been there. So what is your suggestion? I'm just asking for, because see, this is related to internet services and everything. Storage of data,
Indeed.
suppose you are collecting it for any purpose. Banks are collecting it under the KYC norms. Everybody is collecting it. Now it has to be stored, and there may be cases of transfer. Let us take a generalistic view. What are the safeguards because safeguards are provided in the statute. What I am asking, what are the enforcing agencies for this safeguard? Suppose X has taken reasonable care, because the judicial officer who has the quasi-judicial authority who has decided the case, he has decided it on 2-3 grounds. Now this is under challenge before the higher forum. Now the question therefore will be, did Cobalt exercise normal safeguard? If not, what are the enforcing agencies? How can you ask for better protection of that? Because this will in effect give the quasi-judicial authority a guideline. Suppose we decide it in a court is deciding in X this way or that way. Now to come to a conclusion, the court should be given also some details about it, that Cobalt did this or Cobalt did not do this. Now I couldn't find from any of the speakers, both from the petitioner and from the respondent, because you are the fourth speaker, the last speaker, that where is the deficiency? That has to be pinpointed, and then only you can argue a case that yes, the officer or the quasi-judicial officer went. Very well, you proceed now. No. If any other judges have any question, let them definitely.
Much obliged, Your Lordship. If Your Lordships are satisfied with issue 3's submissions, the council seek permission to proceed with issue 4.
Yes.
Much obliged. Your Lordship, issue 4 is whether there is lack of separation of powers within the authority, the data protection authority, as the adjudicating officer and the inquiry officer are being appointed by the same authority. Your Lordship, it is humbly submitted that there is no lack of separation of powers within the authority, even when the adjudicating officer and the inquiry officer are appointed by the same one. Your Lordship, the issue is divided into two limbs. First is the appointment of adjudicating officer and inquiry officer are quasi-judicial functions of the authority itself. So there's no question of separation of power per se. Further, in the second limb, the council will be dealing with that the purpose of doctrine of separation of power is not defeated by the procedure given under the Act. Your Lordship, addressing the first limb, it is humbly submitted that the Data Protection Authority is formed under the Act, which was formed following this Honorable Court's decision in case Puttaswamy versus Union of India, 2017-10 SCC page 1, and the instructions were given to Justice Sri Krishna Committee to formulate a comprehensive legislation for personal data protection. Your Lordship, it is imperative to note that the model of the Data Protection Authority is highly inspired from other sectoral regulators such as SEBI and TRAI, etc. Further, going by the definition of quasi-judicial laid down by this Honorable Court in...
Sorry, Counsel, just I'll pause you for a few seconds here. Two things.
Indeed.
One is you mentioned about Justice Sri Krishna and how Supreme Court was very happy to know that he is, leading. He is the chairman of this committee which is framing the law. Do you know how unhappy Justice Sri Krishna is because of the change that has been made in this regard? Have you heard him? Have you read his pieces in recent times? He's extremely unhappy. So you are, I think that's a very wrong, position to take when you're opening your statement. Number one. Number two is that you just mentioned about TRAI. I think you're spoiling your own case. Are you aware of this DOT TRAI story that went ahead and then there was a split? The reason why TRAI and DOT are separate?
Sincere apologies, Your Lordship. The Council is not aware about the TRAI issue. However, the Council emphasized on the fact that the PDA model is highly inspired from the SEBI model, about which the Council shall be explaining in the issue. Because as far as the appointment of adjudicating officer and the inquiry officer are concerned, and the question of separation of power is coming in, Your Lordship, there is no place for it because SEBI per se is a quasi-judicial body. As the Council said that it is based on the SEBI model, which is a sectoral regulator. Your Lordship, this Honorable Court in Justice Gullapalli Nageshwar Rao versus State of India, 2002 SCC page 655, laid out the definition of quasi-judicial. It said the quasi-judicial functions are the functions conferred on the executive bodies. They are primary adjudicatory functions, which is happening in the present case also. Therefore, Your Lordship, further relying on this Honorable Court's opinion in Indian National Congress versus Institute of Social Welfare and others, for which Your Lordship may refer to page 11 of the memorial. Your Lordship, the Honorable Court opined that where the law requires an authority before arriving at a decision must make an inquiry, such a requirement of law makes it a quasi-judicial body. And this criteria is clearly met in the present matter. Your Lordship, Section 53, Clause 1 and 63, Clause 1 requires the Data Protection Authority to inquire in the dispute when it is received as a complaint and impose penalties only after an inquiry is being made for which the inquiry officer is appointed. Again, it is imperative to note that these are the functions of the authority itself laid down by the legislature on the authority. Therefore, the functioning of the adjudicating officer and the inquiry officer are inherent to the overall working of the authority. Further, Your Lordship,
can may I ask you, what was the legislation involved in Gullapalli Nageshwar Rao versus Andhra Pradesh?
Your Lordship, if you may allow, the Council would like to take the help of the researcher for this one, for this question. Sincere apologies. The Council is not aware of the legislation per se. The Council was focusing on the ruling, the opinion of this Honorable Court. Sincere apologies.
Okay, fine. Please proceed further.
Much obliged, much obliged. As the council was saying, the functions of adjudicating officer and inquiry officer are inherent to the functioning of the Data Protection Authority, which per se is a sectoral regulator. Thereby, there's no question of separation of power in the primary level of functioning of the authority. Further addressing the second limb, Your Lordship, the council humbly submits that the main purpose of democratic principle of separation of power, that is fair trial, is not threatened with the functioning of the authority, because Section 62, Clause 2 of the Act ensures operational segregation, independence, and neutrality of the adjudicating officer appointed under the Act. Further, Section 62, Clause 3 ensures that the officer is in question is a person of ability, integrity, and standing. The council again would like to emphasize on Section 151 of the SEBI Act, on which the PDA model is based. Your Lordship, according to Section 151 of the SEBI Act, empowers the authority to appoint any one of its officers as adjudicating officer for holding an inquiry in the prescribed manner, and similar are the functions of the adjudicating officer under the present act. Your Lordship, it is imperative to note that in the SEBI's functioning, one person is holding the power to adjudicate the penalties and compensation, as well as to conduct an inquiry. Going by that analogy, Your Lordship, there is no question of lack of separation of power within the functioning of the authority.
Counsel,
These were the
with due respect,
Indeed.
if one looks at the statistics of the orders of the adjudicated officers of SEBI being upheld in the tribunal, either SAT or in the High Court, the number is, shockingly dismal.
The council accepts that. However, that is why there is a procedure of checks and balances properly laid down in the legislation, thereby exempting government from the liability of taking the responsibility of not rendering justice to the subject under its jurisdiction. The remedy of appeal, your lordships, is available to the users as a matter of right. That were the humble submissions of the council. The
Council, are you the government counsel for Union of India or a private counsel for Cobalt?
For the both.
So
Cobalt as well as the government.
Are there any submissions specifically on behalf of Cobalt?
Regarding this issue, there is no, Cobalt is not related to issues 5 and 4. It is particularly procedural, your lordship. Issues 4 and 5, it deals with the authority, the Data Protection Authority, thereby concerning the government as well as the legislation. The council seeks permission to move to the last issue, your lordship.
Yes, you can. We will revert back to you since time is very short. You just briefly conclude the last point.
Much obliged, much obliged. Your lordship, issue 5 primarily deals with that. Is there a usurpation of judicial power because the adjudicatory functions are being vested on adjudicating officer who is not a member of any judicial body? Your lordship, it is humbly submitted that there's been no usurpation of judicial power because the adjudicating officer is acting in his executive adjudication. He's acting in his executive functions. Your lordship may refer to para 1, page 13 of the memorial. Your lordship, executive adjudication is a well-recognized concept in the Indian constitutional framework, which was also recognized by this honorable court in several judicial pronouncements, including Tata Motors Limited versus Competition Commission of India, 2019. For the citation, your lordship may refer to footnote 32 of page 13. Your lordship, this honorable court, your lordship, in this case against the CCI, the Competition Commission of India, similar contention was raised that there is a usurpation of judicial power because the adjudicatory functions were vested in a non-judicial body. This honorable court observed that every executive authority is necessarily required to engage itself in some form or manner of adjudication for discharging its duties. That is what the council was arguing in the previous issue, that it is the duty of the authority itself. Therefore, it is in furtherance of the authority that the adjudicating officer is functioning. Further, your lordship, this honorable court in Clariant International Limited versus SEBI held a view that administrative adjudication has become a necessary part of a welfare state due to the modern sociological conditions, and time have necessitated the growth of the administrative bodies. it is further submitted that judicial power per se is not usurpated because decision of adjudicating officer who must be an expert as per expert in the fields of cyber law, information technologies law, technology law, etc. under section 63 clause 2. He has a specialized knowledge of the subjects the council mentioned and not less than 7 years of professional experience in the fields of cyber law, internet laws, etc. Therefore, your lordship, adjudicating officer is merely acting at a primary level, and the users have a remedy of appeal as a matter of right to the appellate tribunal, which the appellate tribunal uniformly are chaired by the judicially trained minds, rather the retired judges of honorable Supreme Courts and High Courts. Your lordship, according to Section 74, it provides that an order passed by the appellate tribunal under this act shall be executable as a decree of a civil court. Your lordship, this section per se is enough to argue that there's been no usurpation of judicial power, because the function of the authority is per se to make sure that the act is being not violated at a very primary level. Therefore, the question of the jurisdiction of civil courts being barred is will not stand here, because the appellate the appeal can also be made can always be made to the appellate tribunal, which has the members from the judiciary. So it's always in their hands what they want to decide. These were the submissions with regard to issue 5, your lordships. The council rests the submissions regarding her issues. If your lordships are satisfied, the council seeks permission to proceed with the prayer.
Yes, please.
Much obliged, much obliged. It is hereafter most humbly submitted before this honorable court that in light of the issues raised, arguments advanced, and the authorities cited, this honorable court may be pleased to uphold the contentions of the respondents and declare that the notification is a good law and is fair and reasonable. Further declare that Cobalt, by sharing the personal data sets with the government and government further sharing it with the Free Republic, was not at all in breach on which the terms was obtained. Further declare that storage of sensitive personal data outside Indian territory and Cobalt's unfortunate failure to maintain security safeguards are not in violation of the provisions of the Act. Further hold that there is no lack of separation of power within the authority. And finally declare that the power to perform adjudicatory functions vested on the adjudicating officer is not at all an usurpation of judicial power. It's been an honor to argue before this court. The council rests her case.
With the permission of the honorable bench, the counsel for the petitioners would like to move on with the rebuttal.
Yes.
Court master, how long is this rebuttals?
Five minutes each, sir. 5 minutes each.
Please proceed.
Much obliged, Your Lordship. Your Lordship, at the very outset, to address my Lord's question, which his Lordship has very advertently raised, Your Lordship, with the issue of continuity of services, and that the deficiency has not been pinpointed. However, Your Lordship, the Council would like to reiterate before this Honorable Court that the issue of continuity of services has been already pre-rebutted as to the fact that it cannot be a valid defense, Your Lordship, given the fact that in Mayor versus the Prime Minister, the Supreme Court of Israel has already settled that in times of such pandemic, it would not be a justifiable excuse to do away with the necessary compliances of the Data Protection Act. Further, to pinpointly answer my Lord's question, the Lordship would be kind enough to note that the Council had pinpointed that Section 24 of the Data Protection Act has mandated the reasonable safeguards that ought to be taken by a data fiduciary and a data processor. For your Lordship, the Council asked this Honorable Court reasonably that how much time does it take to anonymize the data or encrypt the data. Your Lordship, further the contention was that the employees of Cobalt are back at home, thus this cannot be done. Your Lordship, data anonymization, encryption, reasonable standards of safeguards which are prescribed as per the Data Protection Act, these need not need such provision. It can be, one can do it as sitting at the comfort of one's home. Further, Your Lordship, a basic fallacy that the Council would like to point out, wherein Your Lordship, at the very inceptive arguments of the first speaker from the side of the respondents had established that the notification was law under Article 13, Article 13, Clause 1. Your Lordship, while this is accepted, the mandate under Puttaswamy, Your Lordship, the citation being 2017-10 SCC 1, Your Lordship, KS Puttaswamy versus Union of India, Your Lordship, the mandate was that such law must be legislatively enacted. Your Lordship, a notification by no virtue is legislatively enacted. Thus, Your Lordship, at the very outface of it, the notification fails the test of proportionality, which is quintessential to have restrictions on the right to privacy. Further, Your Lordship, when the doctrine of necessity has been invoked by my learned friends, Your Lordship, it has been conveniently ignored that it has very one basic facet, that the harm avoided must not be greater than the harm avoided has to be greater than the harm done, Your Lordship. This has not been complied with in this case, Your Lordship. The harm avoided is the fact that yes, certain medical safeguards have been taken. This, however, Your Lordship, the harm done, and it is actually contrary to on the very basis on which the notification was served. The harm done is that the data has been breached. No valid consent has been taken. The data is out in the open. Your Lordship, what if the terrorists from the state of Zina take this data and cause national security issues? This has been unanswered by the government, and such has not been contended. Further, Your Lordship, the government has taken defense of Section 12F with respect to the transfer of such data. Your Lordship, it is the council points out before this honorable court that Section 12 deals with only personal data. Your Lordship, given the moot proposition, if Your Lordships are kind enough to refer to paragraph 4A, the data is sensitive personal data and not personal data. Thus, the defense of Section 12 Clause F will not sustain, my Lord. Further on, Your Lordship.
Here I have a question.
Yes, certainly, Your Lordship.
Whether Section 14, 1E and F can be placed by your adversary for the protection.
My lord, may the council kindly pray before this his honorable his lordship to pinpoint as to Section 14 of the Data Protection Act.
Yes, Data Protection Act. When
yes, Your Lordship.
14E and F.
Most certainly, Your Lordship. Council shall just look. Your Lordship, with respect to Sections 14, Your Lordship, it is said that in addition to the grounds referred to under Sections 12 and 13, the processing of, again, Your Lordship, it is personal data. Your Lordship, in the given contention, we are dealing with sensitive personal data. Your Lordship, nowhere in the data.
That's fine, counsel. I think the error that has been made by the other side can be, I think, can be overlooked here. The correct reference, should be to, I believe, 13, where right, which provision is talking about sensitive personal data?
Your Lordship, Section 34, subsection 1 is talking about the processing of sensitive personal data. However, Your Lordship, the council would like to kindly put to the notice of this honorable court that it is subject to certain restrictions, Your Lordship, and the restrictions.
No, I understand. See, two things. One is that the restrictions are also there for personal information. Yes, it's only that the degree of
restriction is greater.
Of such restrictions are more.
Most certainly, Your Lordship.
Right. So that is the only distinction. Coming to one of the other points that you were mentioning earlier was in relation to anonymization, how easily things can be anonymized and all that. Do you, counsel, do you understand the difference between a data set that is available with you ordinarily with the name and details of a person versus an anonymized data? Anonymized data would essentially be useless.
Most certainly.
Unless you're trying to do R&D activities.
Most
right?
certainly. Your Lordship.
So the moment you anonymize the data, it is technically understood that you can never go back to the natural person. That's the basic definition of anonymization.
Most certainly.
The moment you were saying that it is anonymized, it becomes kind of useless in a pandemic situation like this.
Most certainly.
You can talk about pseudonymization, but that is also slightly tricky in the present context, right?
Most certainly, Your Lordship, counsel begs ignorance of this fact. However, other safeguards like encryption and such other relevant safeguards could easily be taken, Your Lordship. Further, Your Lordship, the data was with Cobalt from a long time, Your Lordship. Your Lordship, the notification was issued on 30th of March 2020. Your Lordship, within the given time period, Your Lordship, am I to believe that the company could not have taken reasonable security?
No, I think the context is slightly different, counsel. If you read the facts of the case, in the in an office scenario, the security parameters that you apply versus suddenly transitioning to a work from home scenario, it was not possible. Practically, we are all aware it was not possible for any organization to transition its IT system to that level.
Most
That
certainly,
there
Your
would
Lordship.
not be any, and there were initial lacunae, latches, which was which were actually the miscreants had actually
Most certainly, Your
taken
Lordship.
help of that.
However, Council is contending that the safeguards which are mandatory under Section 24 should have been there from the inception.
How
Why
do
the
you know those
safeguards?
were not there?
Most certainly, Your Lordship. Your Lordship.
Because the latch seems to have happened because there was a work from home scenario, right?
Your Lordship, again, this is taking us back to the aspect of storage. Because your Lordship, there was transfer of such data outside the territory, Your Lordship, that should not have been done in the first place, Your Lordship. The
Anyways, I
transfer
think your
is
time is up.
prohibited.
Anything further you would like to say in your rebuttal?
Your Lordship, just one last point, Your Lordship, which the council would like to make is the fact that while two aspects, while Your Lordship, the applicability of force majeure clauses are questionable on privacy policies, Your Lordship, council also contends the fact that while force majeure clauses may exempt the company from liability under the privacy policy, Your Lordship, there is no liability from exemption of liability from statutory provisions. Further, Your Lordship, the parameteria drawn to the SEBI model does not hold value over here, given the fact that, Your Lordship, the SEBI model is essentially a sectoral regulator and is involved in adjudication of statutory provisions, Your Lordship. In the given case, Your Lordship, the Data Protection Authority is more than a sectoral regulator. It has many more functions, Your Lordships. Further, it is something. It is a body which is protecting the fundamental right, Your Lordship. Again, Council is reiterating that a violation of the Data Protection Act is a violation of the fundamental right to privacy. With
Thank
that, Your
you.
Lordship, Council would not take any more of the court's precious time. Much obliged, Your Lordship. It was a pleasure pleading before this honorable bench.
Thank you.
Do the respondents get any rebuttal as well?
Yes, I think so.
Court Master?
Yes, who is going to take on behalf of respondent? Who is going to take the rebuttal?
Your Lordship, the petitioner side has asked us quite a few things. So the council seeks permission that speaker 1 would answer some questions and speaker 2 would answer some.
Okay, if others are
Yes,
fine.
please proceed.
Yeah.
Your Lordship, petitioner has said that in case Puttaswamy versus Union of India, the court observed that a simple notification does not satisfy the requirement of a valid law. Your Lordship, the council has already established that this was not a mere notification. This notification had a backing of the law. The law itself, Section 35 itself says that the government can come up with such an order and can make the processing of personal data sets, make the provisions of the act inapplicable to the processing of personal data sets by the government. Hence, the notification was very much in the purview of the law itself. Answering the other question about the distinction of personal data and sensitive personal data, Your Lordship may refer to the very definition of sensitive personal data. It is written, it is to be understood as a subset of personal data. Your Lordship can refer for the context that Section 12 does away with the requirement of taking consent for processing personal data on certain conditions, one of them being while responding to medical health emergency. Your Lordship, how is this logical that while responding to medical health emergency, sensitive data, that is medical health data, which comes under the category of sensitive data, cannot be used? Hence, the two questions of the petitioner side.
No, here I have a question. I may interrupt you. If you come to the definition 236, it gives that of the personal sensitive data. Personal data has been defined elsewhere. Now the other side is trying to make a distinction that in respect of personal data, section 12, 13, 14 will apply. In respect of personal sensitive data, these provisions will not apply. What do you have to say about it?
Your Lordship, can you please read the definition of sensitive personal data from the very beginning, the first line?
Yes.
So
Counsel,
council, let
it is
me just
only
make
it
it.
is only appropriate you read and lead the judges
Yes,
rather
Your
than
Lordship, I would take a minute for that.
So whilst you are doing that, counsel, let me tell you why it is all the more important for you to know the distinction and how still personal data has been handled very differently from sensitive data. When you're talking about transfer of personal data slash sensitive personal data from the country outside, the revised position under the 2019 bill, which you are arguing on right now as an act, it says that personal data can freely go outside. So the case completely changes, right? 2000
Yes.
and sensitive personal data, it is stated that there are certain catches, there are certain parameters attached. It is only then it can go out of India. So it's very cardinal difference. Don't try to use that broad brush language which is there. We all know it has to be, before becoming sensitive personal data, that has to be personal data first. That's absolutely clear to all of us. But what we are alluding to here is the treatment of personal data versus the treatment of sensitive personal data, right? So it's a correct point made by the other side, and
Your
it is
Lordship,
important in this context also.
Your Lordship, the only submission is that sensitive personal data is a subset of personal data. So Section 12, when it uses the word personal data, it includes sensitive personal data. Given the context, given the 12V, it specifically, categorically says that
No, no. If that be so, then the legislature wouldn't have used two different definition, 236 for personal sensitive personal data and the other section for personal data. As Mr. Chakraborty has correctly showed or had correctly said while explaining that personal data, sensitive personal data is a generic term which includes all aspects. Now, under that, you have only few things which will include under 236 the sensitive personal data. Now, that what you say?
Your Lordship, I would just read the definition of sensitive personal data. I would take a minute here. Your Lordship, it says means such personal data. Sensitive personal data means such personal data, which may or may relate to following details. So, Your Lordship, the point is that there is only the distinction between sensitive personal data and personal data with regard to the section, with regard to 11 sub 11 clause 3, where it requires that there should be explicit consent while processing sensitive personal data, which is done away with when we apply section 12.
Oh, if you come to that's what I am showing you. You come to 228. 228 is the personal data. You
Yes,
have
Your
a
Lordship.
copy?
Yes, Your Lordship, I do.
Then 229, personal data breach, means an unauthorized. So personal data includes sensitive personal data. This is your argument. And you are using the section 12 cover 12 and 13 that there has been no breach in the moot court problem. That is what you are trying to say. Now, my question was, if that be so, then why has the two so differently defined? The legislature could have stopped by using 228 instead of including 236. And later on, if you come to 33 and 34, there also the word uses sensitive personal data. What do you say about it?
Your Lordship, the argument pertains to the issues that are covered by Council, the Speaker 2. Speaker 2 would be in a better position to answer your question.
Very well, timekeeper. Do we have 5 minutes time since counsel 2 for the respondent one is not able to answer and wants counsel 2 from the respondent side to answer, though rebuttal time is over, can we give her 2-3 minutes time if she wants to
Sure, sir.
access?
Extension can be granted. Sure.
Give her 2-3 minutes time, very
Sure, sir.
shortly.
Sure, sir.
Much obliged, Your Lordship. Your Lordship, addressing the question related, which my learned counsel posed, that Clause 7 exempts the Cobalt and the government from their contractual liabilities. However, the learned counsel forgot that the privacy policy itself was drafted under Section 22 of the Act, thereby immuning them from the provisions of the Act also. Further, Your Lordship answered my question in a way when you posed that question, that why were security safeguards not taken. There were no, as I was mentioning in my submissions, that there was no time at all. It was all done on a real time basis, and had the security safeguards being implemented, the services of the app would have stopped. Therefore, and the last contention which my learned counsel raised, that the SEBI model cannot be relied upon. I would like to clarify to the learned counsel that that the SEBI model is the model from which Sri Krishna Committee inspired the PDA model from, and your claim is unsubstantiated, and it is not based on any legal backing. That the Data Protection Authority is a fourth branch regulator. It's just a sectoral regulator based on many other such bodies, which this honorable court has recognized their quasi judicial functions.
Counsel, thank
That's
you
it.
for latching on to my words on when I say that people had to quickly move on to work from home scenario. But let me tell you the solution to that. The way to do these things are the moment you realize that the security measures will not be as good when you move to a work from home scenario, it is but appropriate that you reach out to the relevant natural persons whose data would be handled from a different location in a different manner with a lesser degree of security. And in today's world, in the e-world, that is not very difficult, right? It's a pop-up, it's a click through where you clearly tell the natural persons, data subjects, that how things are happening differently because of the COVID situation. Now, that to my would have been the correct approach in this case.
Much
Yeah,
obliged.
since you had all the time to publish a yellow pages, I'm sure you had enough time to send mass SMS and say yes by SMSing 1 or no by SMSing 2.
Regarding what, Your Lordship?
The consent.
Consent. Your Lordship, millions of peoples were involved. Your Lordship, India is the second most population of the world. A lot of time would have been, invested in this
Yellow
procedure.
pages was also published. I'm only saying, to seek consent, it will take the same time with high-tech IT at our disposal. Especially this current government has a very good IT ministry. That's for a later date.
Indeed, Your Lordship. The council, however, would stick to her arguments that the Cobalt and the government are still exempted from their liabilities, given the sections of the Act as well as judicial pronouncements by this honorable court itself. Thank you.
Thank
Thank you.
Thank you to the